Morning, everybody, and welcome to our latest webinar. Today, I'm joined again by Will Eastman, who heads up our legal and claims team. And Will's here today to give us the latest news within the lettings industry. Morning, Will.
Morning, and thank you. Morning, everybody.
Your lampshade in the background is very, very nice.
Well, I'm trying to match the shirt, I think.
Brilliant. So obviously today we're joined by a large number of our customers across the three brands. So we've got customers from Let Alliance, Rent Shield and Homelet. So welcome everybody. And obviously thank you for taking the time out of your day to join us. We are live, so we'll try not to do anything we shouldn't do. We've got the Q&A function. So if you've got any questions, feel free to ask during the webinar. We'll try and answer as many as we can. Obviously, if there is any questions we can't answer, we'll take them off and we'll make contact with you separately. So just before we get going, Will, obviously we're going to spend a bit of time, quite a lot of time, talking about the new breathing space regulation. But just before we do that, do you want to just give us a bit of an update as to what the legal and claims team are up to in a minute, what's happening?
Yeah, so for us, it's a really exciting time, I think, as a business, not just as a department, and we're growing at a rate we haven't grown at before. So, of course, with more customers comes more claims, and so we're also very busy in the background handling claims of people. So the team is split across Chester for our Let Alliance brand and Lincoln for our Homelet and Rent Shield brands, and we're both equally as busy and working hard with all of those claims that are coming in from customers. And just to throw on top, we've got all of the legislative changes or the regulation changes that I'm sure many of the customers are also trying to battle with and come to grips with, that we're embedding into what we do every day. So yeah, we've got a good group of people working really hard.
Brilliant. And that's one of the reasons why we're hosting the webinar today, is to try and support our customers the best as we can to let them know what's going on. So okay, on to the breathing space regulation. And so tell us, Will, what is the breathing space regulation that's coming into force on the 4th of May?
Yeah, so the official name, and I'll have to read it because it's really long, is the Debt Respite Scheme, Breathing Space Moratorium and Mental Health Crisis Moratorium, England and Wales Regulations 2020. So yeah, breathing space for short. But as you say, it comes into force 4th of May this year, applies to England and Wales. And it creates two types of breathing space that, for us, tenants can get access to. And the standard breathing space provides a period of 60 days, and the mental health breathing space that's available is slightly different. That's for the duration of the crisis treatment, plus 30 days after that's finished. But the purpose of that, I think, has been introduced to deal with individuals that are struggling with debt. So it's a short period of time, so they can get the finances in order and find a solution that helps them moving forward, which I think is a very fitting time to come in, given where we are in the pandemic and the debt crisis that people are predicting off the back of that.
So I guess the big question here really is, can a tenant now avoid paying rent and then have breathing space?
I don't think that's the purpose of it, and the regulations as they're written certainly doesn't suggest that that's the case. So not all tenants are able to get this period of breathing space, and they have to have had advice from a debt advisor, whether that's a free independent debt advisor or a local authority that gives debt advice to its residents. They're the only ones that can apply for this breathing space on their behalf, and there is a strict criteria that they have to meet in respect of getting that breathing space. The debt has to be a qualifying debt, as the regulations say, and rent arrears is encompassed within that. That is a qualifying debt. But I think the key thing to this is it is for debts that have arisen and not ongoing liabilities. So any tenant that applies for this type of breathing space must be able to meet their ongoing rental payments to be eligible for this type of breathing space. And they also, for the standard breathing space of 60 days, they also can't have had any of this in the last 12 months. So they can't have a debt relief order or a bankruptcy or this type of breathing space in the last 12 months. That's slightly different for the mental health one because there isn't a requirement on there, but certainly for the standard ones.
Okay, and who makes the decision then whether a tenant is eligible to qualify for the breathing space?
So the regulations suggest the Secretary of State makes that decision, but I think in practice there's going to be an electronic register that's kept up to date and managed by the Insolvency Service. So a debt advisor will go through all of the criteria with the individual, and if they're satisfied that everything's met, they'll confirm to the Insolvency Service that they want an entry on that register and that all the criteria necessary has been met. So in practice, it'll be the Insolvency Service that sort of govern that electronic register.
Okay, so the sort of next question I'm going to ask you, and this will probably be one of the most important bits our customers are probably going to try and take away from today. So for a tenant who has been granted a period of breathing space, what can't a landlord or an agent do during that period?
There's quite a bit that they can't do for that 60 days. So the purpose of it is to stop interest being applied, fees being applied, or tenants chased for those rent arrears that have arisen at the point of the application. Again, we go back to ongoing liabilities are still payable, so a tenant shouldn't then continue to fail to pay the rent. And so they can't chase for those rent arrears. They can't discuss that or correspond with the tenant in relation to payment. They can't apply interest and fees. And because they can't demand it, that means you can't serve a Section 8 notice. So because that is a demand for rent, you can't go down that route. You can't start legal proceedings for any sum of that debt during that period. And it applies to joint tenants as well. So if your tenancy agreement applies joint and several liability to the tenants, and one tenant has breathing space, you can't chase the other tenants that are joint to that debt. But what you can do is still chase guarantors. So if there's a guarantor that's in place, they're not party to that unless they go off and get their own period of breathing space. You can still serve Section 21s because they're not debt related. And any live proceedings that have already been started can continue up until the point you get your court order. But the enforcement of that court order can't take place until the end of that breathing space.
Okay, fine. I think what we'll do, when we get to the end, we'll go back through that again so everyone's clear. Just as a reminder, you have got the option to ask us any questions. Thanks for Rebecca Clark. She said hello to both of us as well, Will. So that's very nice. Hello, Rebecca.
Yeah.
So obviously from your own experience, Will, what do you think the practical impact of these regulations is going to be on maybe how our letting agents, landlords, and us ourselves as in a provider of rent guarantee, how do you think it's going to impact us?
So I think many people have probably seen this as another blow to their landlords or the letting agents, as tenants. The majority of tenants don't pay their rent because of a serious change in their life, or the pandemic, the most recent change. There's a minority that will take advantage of that, and I think people have probably taken this as another blow, another piece of regulation that supports tenants and not landlords. And I can see why people would think that, but I don't think this is going to have a huge practical impact on landlords. One, not all tenants are eligible for this, and the criteria that has to be met isn't going to be met by all tenants. So if a tenant has missed rental payments and they simply can't pay their rent moving forwards, then breathing space isn't going to help them. They have to meet their ongoing liabilities. If they're keeping up with their ongoing liabilities, then it's a good thing for landlords for tenants to go and get the help to repay those arrears that have accrued, rather than them bury their head in the sand and sort of try and disappear and landlords try and get hold of them. I think it's a good thing for landlords there. Obviously, like I say, any court proceedings that have already started will carry on until we get the judgment. So it's not going to delay that part of the process. And it's only the enforcement of those orders that would be delayed. The mental health moratorium is probably a bit different. So that's not 60 days. That's any period of crisis treatment plus 30 days after that's finished. But I think I'm not a medical expert, but my view on that is mental health crisis treatment, I would say, doesn't very often last longer than 60 days. So I don't think it puts any more of a burden on than the standard one. And where that crisis treatment is going to last longer than 60 days, the chances are that the professionals helping that individual will probably want to think about surrendering the tenancy and stopping that liability of rent arrears growing over a period of time. So the practical impact, I think, is there's going to be some impact. It's there for a purpose, but I don't think it's a huge impact on landlords, and I think we'll see very little of it. But the key thing is any of the tenants that go into that and then don't pay their ongoing liabilities, creditors, i.e. landlords or anyone acting on their behalf, can apply to those debt advisors and ask for them to review the breathing space with a view of cancelling it for not meeting their ongoing liabilities.
Okay, brilliant. So how are we preparing, Will, in obviously both Chester and Lincoln? How were the team preparing for the changes in the legal and claims department?
So we've been changing the way we work probably for quite some time because of all the changes last year, and a lot of the work is probably embedded within that. So we're a lot more in contact with tenants and guarantors earlier on in the process, setting up repayment plans, etc. But for this specific regulation, in our recoveries team, we already have breathing space and we already provide that during recovering outstanding balances. So for them, no change. For our claims teams across Chester and Lincoln, we're already in the process of changing all of our processes to adapt, make sure we comply with it, but equally make sure all of the landlord's positions protected for those minority tenants that may get a period of breathing space and not continue to pay the rent. So we already have processes in place to identify that and deal with it by writing to debt advisors.
Okay, so just to reiterate then, so anyone who has been granted a period of breathing space, a landlord or an agent, they can't correspond with that tenant during that period. A Section 8 can't be served. We can't start legal proceedings. We can't enforce an order. But well, also we can't chase any joint tenants or anything on there as well. But they can still talk to guarantors and chase guarantors for any outstanding monies. Is that summarised well enough, Will?
Yeah, the only point I think to point out is you can correspond with the tenants if it's not related to do with the debt that's subject to the breathing space. So anything else about maintenance or anything like that, you absolutely can speak with the tenants about. You just can't ask them to pay the debt or chase that debt. Yeah,
okay. So moving on then to some changes that we've had, some exciting changes, obviously over the last couple of months from a rent guarantee point of view. Normally this would be my job, Will, in sales. I think today we're going to have a different person talking about the new offering. So talk us through, Will, the changes we've made. Obviously there's been two elements of these changes and what the key ones are.
Okay, so 1st of March this year, we changed our rent guarantee offering to our customers, and the key changes to that were increasing how many months rent we pay. So as of the 1st of March, existing customers as well, so you don't have to wait to renewal, it's existing and new customers will get payments of rent guarantee up until vacant possession or up to 15 months maximum. So whichever comes first will receive that many payments. We've doubled our legal cost cover. So it was £50,000. It's now £100,000. And we include defended matters now, which I think is, from a claims perspective, probably quite biased, is a really important part for us. Previously, we didn't cover defended matters. So if a tenant raised a defence, landlords and letting agents would have to go off, resolve it and come back to us. We keep hold of it now. So we continue to pay rent guarantee and we continue to do all of the legal work to resolve those defences and get possession.
Just on that, Will, as well, do you think in current climates, defended claims are going to be on the increase?
Yeah, I do. So part of the changes that came out of the overall arrangements late last year was the introduction of a review hearing. So a review, it used to be one possession hearing and you'd go and you'd have your 5 minutes in court and get a possession order. And now there's a review hearing as an interim step where they review the papers. But the important part of that is giving tenants the opportunity to get free advice from a duty solicitor. So there's a lot more touch points now for a defendant, a tenant or a guarantor to get free legal advice. So absolutely, I think tenants are more aware. They've got more free legal advice. Defences will come in, I think, a lot more now that all of those processes are in place.
Okay. Just as an FYI, I am in an office where the lights are motion censored and I've obviously not moved for a while, so they have just gone off. So there's no power cut in HomeLet, don't worry. So I've got a question actually from Kelly, sort of going back to the breathing space regulation that we've been talking about. So are there any guidelines, RE clearing the debt after the breathing space has expired?
So it depends on what happens after that. So that 60-day period is for the tenant and the debt advisor to work out a solution that then resolves the debt issues. And that's the purpose of it. So you would hope that at the end of those 60 days, the debt advisor is gone and there is a debt relief order or some sort of repayment plan in place with creditors to repay that debt. Now, of course, at the end of that 60 days, if there's been no alternative solution, then it goes back to the drawing board of what we would usually do, of including it in proceedings and pursuing it that way. So the purpose of it is to get a solution in place, and hopefully that in practice that's what happens. But there is no specific guidance as such on that aspect.
All right, perfect, brilliant. Hopefully that answers your question, Kelly. Again, just a reminder, the Q&A function is open. If anyone has got any questions, now is the time to ask, while we've got Will Eastman, the expert on rent and legal claims. So just flipping back, Will, back to the new offering. Obviously, you've spoken about the changes. We know, across the board, we're excited about, giving our agents the opportunity to have the best rent guarantee out there on the market. Why, from a legal and claims perspective, why do you think it's important that, agents purchase our rent guarantee other than one of the other products on the market?
It's a really good question, I think, a really interesting question. And for me, being quite technical in background, my personal opinion is the devil is always in the detail. So insurance is brought because when things go wrong, you want that policy to cover you. You want it to be the most comprehensive policy that you've got, and you want it to pay out. And over the past probably 12 months, I've seen similar policies out there in the market that have really creative clauses in that say, you know what, any disruption to the court system or anything like that, we're going to suspend or accrue the benefit of the policy till a later date. I've heard people defend those clauses on the basis that, you know what, we're a regulated business, we're not going to not pay claims. I think my question to that is, well, why is it even in your terms? And there's a lot of drive, I think, in the market about automation and tech-driven processes. And the claims in landlord and tenant disputes are unique in every way. So yes, you have your general themes of non-payment of rent, but the tenant will have a reason for that that's different in most cases. And there's nuances all the way through those landlord and tenant disputes. So for me, there is no one solution that you can deliver on a tech or automated basis that will cater with a tailored, a bespoke claims handling service for customers, which is what they really need at a time where they need support. And I know for a lot of landlords, just the concept of legal work is quite a scary thing. And when you think of solicitors, I think the layperson out there, like a landlord who's not experiencing it, will probably think that's going to cost a lot of money. And the scariness is the unknown in that. So for me, we don't have a lot of automated processes because we think people and that human touch is key. We can tailor our claim service to that. And you simply can't achieve that with automated. I mean, I've seen out there that there's a challenge on, well, automate it and take the onus off letting agents, for example, in contacting tenants when they fall into rent arrears. And that's great. We have in all of our policies, we have a term that says you should contact tenants in 7 days, and if they don't respond, in another 7 days, so 14 days from when the rent falls due. And for us, that's a really key part. So yes, we could replace that with scripted SMS or emails, but then you're submitting claims to us a lot earlier than they need to be, because sometimes a phone call with the tenant resolves it, no claim needed. And for me, I sort of go, the question is, what is better? An automated text that's scripted, the same text that every tenant gets, or a conversation with the people at the letting agent or the landlord where the tenant has built that relationship, they know who they are, and they can have that honest, open conversation. So for me, conversations are key, and the way we do things is tailored, and we have that personal touch.
I think the other big thing, Will, to add really, you know, agents will work their hardest, you know, or one of the hardest times when a tenant isn't paying. You know, when they're having to chase a tenant and the landlord's phoning asking them to, you know, where is their rent, etc. When are they going to get their rent? You know, by having a rent protection in place, it's not only meaning the landlord gets their money, it means, you know, it's a smoother process for our agents. You know, they're also receiving their management fee, because otherwise they're not getting paid for all that additional work they're doing, etc. So, you know, even from that regard, it sort of takes a lot of time away and protects their own income as a business, as well as the rent. So
yeah.
For
us, if you look at the Home Let and the Let Alliance, the model of the way we work, our referencing, our sales process, our underwriters, our claims, our compliance teams, all of that is under one roof. So it's all of one roof for Home Let and Rent Shield in Lincoln, and it's all under one roof in Chester for our Let Alliance brands. And there's no other provider out there in the market that has that oversight control all in one place. They outsource a bit to their claims function, and then they outsource their legal bit to a solicitor's firm, and we do all of that in-house. So we see it from end to end, from referencing a tenant right through to recovering all the money paid out in a claim. And at any one point, we have full control of that process. So when we don't do cheap and automated, what we do is tailored and bespoke services at competitive prices.
And at a time when, you know, a landlord or an agent is most wanting that guidance and support. So brilliant. You'll be pleased to know we've got some questions. So we've got a question from Hannah. Hello, Hannah. Could you explain more on the mental health breathing space, please? They currently have a tenancy. I'm assuming where the tenant is receiving some treatment in a minute. I don't know if there's anything more, Will, you can maybe add to that for Hannah, or whether we might sort of want to make contact with Hannah separately and see what we can advise.
So at a really high level, and I'm happy separately to go into a bit more detail if you need, Hannah. So at a high level, it has to be crisis treatment, mental health crisis treatment, and the people that apply for that breathing space period are the medical professionals or social workers, support workers. So it's not the tenant, it's their support network. In a similar way, it will go through the insolvency register, and they will put it onto the register, and they have a period of breathing space. That breathing space is for the entire duration of their crisis treatment. And when their crisis treatment is finished, for another 30 days thereafter. So it's only after that point that the breathing space finishes. And all of those same rules apply, as in you can't chase the debt, you can't start a legal action, all of that sort of stuff still applies in that. So yes, it could be a little bit longer than the 60 days, but if it's going to be a prolonged period of crisis treatment, it's probably worth reaching out to those social workers or the key workers involved to see what the future plan is for that tenant and the tenancy, because it may well be they're happy to surrender it because the individual is going into some sort of monitored housing or something like that.
Okay. Hannah, if that doesn't give you enough info and you want a bit more, just make contact with your account manager, and we can maybe book some time in for Will to go into a bit more detail. A question from Sharon. Hello, Sharon. Her question is, what is the purpose of having a hearing review? Can the judge grant a possession order at the hearing review, or do we still need to wait for the actual hearing?
Very, very rare you'll ever see a judge grant a possession order at the review. So the purpose of that review hearing is for the judge to review all of the papers, make sure all the paperwork is in order, they have everything they need, they're satisfied, and for the tenant to get legal advice. So it's just another step inserted in there that is intended to provide the tenant with some legal advice and cut out any claims that shouldn't be proceeding. So ensuring landlords are working with tenants, sort of try to resolve the situation before relying on the court. It's in practice, it's probably not worked how they intended it to. I know there's some courts out there that are simply moving away from review hearings. So I think we've seen Birmingham as a court who have simply said, we're not going to do review hearings because they're not working. But a lot of the courts are still doing them. So the purpose is for the judge to review the papers and the tenant to get some free legal advice.
Brilliant, thank you. That probably links into a question for me to ask, actually. Are we finding different courts in different parts of the country are acting differently or at different stages of introducing changes, or do you find it quite consistent across the country?
No. So courts they all do it in their own unique way. Generally, there's a really high level process that they follow, but individually in the courts, it differs from judge to judge and court to court. So a lot of the judges sit in a circuit of courts. So in that area, there'll be specific judges. And yeah, there's differences and nuances between the processes. So an example being some judges are willing at the hearing to grant permission for the exception to the evictions ban. So if there's more than 6 months rent arrears, or it's 6 months or more, you can apply for a bailiff as an exception to the current ban, as it's called. And at the hearing, a lot of judges are granting that permission rather than having to make separate applications later on down the line. But there are some that are refusing to deal with it at the hearing and expecting landlords or the legal representatives to apply for it later on and deal with it later, which of course prolongs it a little bit more.
Okay, I guess that's just another reason to obviously have a claims team that understand how various courts work in maybe different areas of the country. Obviously we have a large experience. Unfortunately, obviously we deal with a large volume of claims due to the volume of rent guarantee policies we cover. So having that knowledge also helps us understand maybe the challenges we're going to get with individual courts. So
absolutely, yeah.
So no. Question from Karen. Morning, Karen. Probably a question that I can answer, Will. I'll let you have a break on this one. In the event of a claim being accepted, does the rent get paid directly to the landlord or to the letting agent? The actual rent will get paid to you as the letting agent. The benefit of that means you can obviously then deduct your management fee and then pay the rest of the monies onto the landlord. So it goes back to my point of having the rent protection in place isn't just protecting the rent, it's protecting your management income as well. Karen, if rent guarantee isn't something that you're obviously promoting or offering at the minute and you want to, again, get in touch with us. My email address is chris.turner@homelet.co.uk. Drop me a note and we can have a chat on that. That's all the questions I've got at the minute. Well, is there anything else you wanted to add? I don't know if you maybe wanted to give us a bit of an update on some of the dates around the current eviction bans and notices at the moment.
Yeah, so most people on here have probably seen that the eviction ban in England has moved. It was originally ending the 22nd of February. That moved to the end of March, and now that's moved to the end of May. And that's a similar date for the extended notice periods. So the 6 month notice periods, the Section 21s and Section 8s, has also moved to the end of May now. For commercial tenancies, if there's anyone out there dealing with commercial tenancies, the eviction ban is now pushed over till the 30th of June.
Okay, perfect, brilliant. Okay, was there anything else, Will, you wanted to ask at all or tell us, or?
No, probably just a reminder for anyone out there that the 1st of April, all tenancies will require a electrical safety check having been carried out for the 1st of April this year. So it's probably worth, if you haven't, getting onto that. But other than that, that's me done.
Okay, perfect, brilliant. Well, thank you everybody for joining us. Hopefully you found it beneficial. Again, as I say, we're excited with the rent guarantee product that we've got on the market. So if anyone wants any further information, etc., contact Homelet, Let Alliance, Rent Shield, your account manager, or you're more than welcome to drop me an email on chris.turner@homelet.co.uk. Thanks, Will, for your time. Great insight. I'm sure we'll probably bring you back in a month or so, and we can have an update, as it sounds like the changes are going to continue. Yep. But we can go from there. All right, thank you, everyone. Enjoy the rest of your days, and we'll speak soon.
Thank you.